is a colonial relic and all of that. Colonial judges needed to go on vacation and everything. Whatever it is history, I can tell you that lawyers need that vacation. It's not just lawyers, but judges. Very, very. And when people say this, they don't even understand that during the vacation, there's still a lot of work that lawyers do. There's a lot of written submissions that they are writing for their clients. You are writing several pages. You are reading several records that are very huge. You get into my office and you see records of 6, 7, 8 volumes. And I'm reading all of that in the vacation. So the only thing that is taken away, or the only thing that you get reprieve from during the vacation, is court attendance.
But you're still working.
Yes. I think maybe lawyers don't tell their story well, but the legal vacation is very important for lawyers. It's clarity we all need on this matter. I explained one point. When they say we are on legal vacation, it doesn't mean no work is done. So traditionally, every year during the legal vacation, the Chief Justice, as the head or the administrative head of the judiciary, appoints judges to sit during the vacation. They sit during the vacation, and by tradition, they are understood to be dealing generally with specific types of cases, like general applications, matters which are urgent. If somebody has been detained, you need a writ of habeas corpus, and all, it doesn't have to abide. You need abide the legal vacation. Somebody wants an injunction. He's not going to wait until lawyers come back from their vacation, however tired they are. He's not going to wait. So you have those matters which can be dealt with by judges sitting during the vacation all over the country. It also happens, so the Chief Justice has that power as the administrative head of the institution to appoint judges to sit. The Chief Justice does not direct how the judge should deal with those cases before him. You should appear before the judge and make your case to the judge. That, look, I have been appearing before you throughout this period. I think I need some time off to be able to refresh and come back. The judge has power to adjourn it, and the Chief Justice can't control it. And I'm saying that it is not even the first time that lawyers have appeared in what are supposed to be politically sensitive matters during the vacation. But if as soon as a decision is taken, you don't engage the decision in any way, and you are hearing news about how people are biased and press conferences are being organized, that's not how to resolve it. And that's not a legal way of resolving issues. There are certain cases people call political cases or cases of public interest, national interest, and all of that. You can tag them as you like. And you can emotionally connect with them as you like. You can emotionally react to them as you like. Is that the proper way to deal with it? You should ask yourself. That if you go on radio to speak about it, do you get a solution or you inflame passions? They can't. I'm not. Sometimes, I mean, with all due respect to my colleagues, some of whom are senior to me, they are my good friends. You can't say you are boycotting courts. In fact, it is unethical to say you are boycotting court. You are you are an officer of that court. So even though you have a duty to serve your client, your primary duty is to the court, because we all are assisting the court to serve justice. And so when you say you are boycotting, this is not a TUC type of situation, or sorry, excuse TUC people should spare me. An officer of the court, you owe the court a responsibility to appear before that court
and make your case.
And the court has powers of discipline over lawyers. That a court can say appear, and you say defiantly that I won't appear. You owe that court a duty to go to the court and explain to the court that yes, this is my constraint. When we as officers of the court say we are not coming, what impression then are we giving to those who are not supposed to be learned in the law? That a court can say this and I'll say I won't do it. The best way was to have written a letter and said, oh, we are siding one way or the other. Can you even go and you have what it takes as an association representing us as lawyers to walk to the Chief Justice to say, we have seen this your circular, we want to come and engage you on it. And this is what was the circular about, what is it intended to achieve, could we do it this way? The Chief Justice would benefit enormously. He will be very enriched by some of the suggestions you will make to him that will help the judicial system, the public, and the lawyers that you are representing. What is for me, reacting to it in that way didn't make any sense. And I've said before that as a member, I don't think they represent me. Because in every situation that I was in trouble, I never saw them. I have never felt represented by them. Because I said in many instances in which I was in trouble as their member, I didn't even get a solidarity call. No, even when I met them casually, did any of them say, oh, we've seen what you are going through, but don't you think we should do it one way or nothing like that? But I'd rather see you on the other side fighting against me, your member. So when they issue a statement like that, I have no respect for it. I'm sorry. And if you show respect to them, if you write that type of letter, put out there in the media to the Chief Justice, if he doesn't put on a matured cap, his reaction to it would be negative. That you are the Bar Association, but I am the Chief Justice of the Republic of Ghana. So it set bad standards and very low standards. And as a member, I think we need a revolution within us. Eddie now was given 70 some. In fact, the prosecution initially made a mistake. There were 78 charges. They said there were 80. It was a trial judge who found that they didn't even count their own charges well.
It was 78.
Yes,
and they said
it was 80. It was a trial judge who said no. I've even found out that they are not 80. They are 78. Your own charges, you couldn't count them. So you should see right from the beginning how when you speak out there about a case and when you get into a courtroom and we're now picking the pieces one after the other, so we get to the truth. Excuse me again, let me use this example. We have our finance minister who is taking advantage, and the supposed most advanced country in the rule of law and in democracy and who teaches us how we should respect people's rights, is allowing him every opportunity to take a point that he wants to take for his benefit. Why is it that when it was in our country, Abu Trika and Co didn't get that right to be able to take point by point to the Supreme Court and have their rights declared before they were repatriated? As for oral will take time. So let's understand that at the time oral was put out there to all of us, it was based on particular information. That is one step of it. The next step is, if you launch an attack against somebody, a judicial one against somebody, it's not going to be like the one that was said on radio, that it is oral. We are going to pick the pieces one after the other until we get to
evidence based.
Yes.
Will you want to be a judge?
Well, no.
No? Not
at all. Well, maybe I don't think I have what it takes to be a judge, I'll be honest with you. The kind of
patience, you don't have what it takes to be a judge?
No, I don't have what it takes. They are very... you have to be an extreme... I mean, somebody with good qualities. I'm not sure I can sit there for 1 hour. See what I see come from lawyers like myself. I'm not sure I can tolerate that.